stores soon. Natalie, thank you for your patience.
Some people
It's
so
okay,
want
it's
in
okay.
Compton too, so yeah.
It's totally fine. He had to go. So too bad he's not here because he stole part of my first question. And then I was going to just add up to something. So first of all, thank you. That was brilliant. I mean, I've taken so many notes.
So are you a positivist now?
No,
Okay.
definitely not. That's why I've got some points here. Since we're already talking about how judges decide, I guess I'm going to start with that one. That was my last one. But then, if I understood well, you consider yourself an exclusive positivist and not normative, so no Kelsenian.
Right.
All right. But then, in chapter 8 of the pure theory of law, sorry, because in Portuguese it comes to my head in Portuguese. So, but then in chapter 8, I don't know if the exclusive positivists do agree with that or not, and so I would ask if you do. It says it's possible, just to summarize, it's possible for judges to judge contra legem, so against the law. So it wouldn't be a question of judging A or not A, but against the law itself, as in that validity question. So we've got law itself in a positivist way, so piece of paper and then ink on it, and the judge is deciding completely against it, and it would still be valid since we're talking about validity, and it's still under the positivist view. So I would ask you if you agree with that.
Yeah, probably.
Okay. Secondly, that's the problem to me. But so, secondly, there's maybe a follow-up question I would have to ask before doing my second point, which is, do you believe there is an international law that exists?
Law. Yeah.
Okay. So that's because I'm an international law professor. That's why I'm going to dive into this just a little bit. Mm-hmm. The thing is, international law is 99% built on customary law. So
good.
Yeah, it became on paper probably 100 years ago. So it bases on customary law, and there is something special about international law, which is jus cogens or jus cogens. I do not speak Latin, have no idea, which is probably all of you know. So I'm just going to mention briefly. Basically, the recognition of obligations for states towards states between themselves and to their nationals as well, and to other nationals. I mean, to all humans. Beyond their will, so beyond their voluntarism. So they do not have to agree. For example, prohibition of torture, prohibition of slavery, self-determination of peoples. We've got many examples. So that means it does not pass to all that bureaucracy of validity we were talking about, but it's still law. So how would that be viewed by your point of view, please?
Great.
And just the last thing I wrote here is kind of an example that went through my mind is if a country passes an act, so let's say law by itself, formally, bureaucratically speaking, law, stating that a part of the community, let's say any part of the community, let's take a minority, for example, because that happens quite a lot. So, for example, LGBT community. So all those people are now, by existence, illegal. So they cannot be what they are because, well, that law just passes. And the Congress has done its job, and that has become an act. And the president, so I'm going to say president, not king, because in my country it's the president. The president has given its okay towards that. So now those people, I don't know what the consequence would be, like pay a fee, or maybe just go to prison, or maybe even genocide. I don't know. That could be anything. So that's still a valid law because it went through all these bureaucratic things.
Yeah.
So thank you so much. That would be my 3 points.
Okay, so Kelsen, sounds right. I'd have to go back and read that specific passage, but under this, if the judges said something that was completely against the law, then again, assuming that we're not in a situation where no one would listen to the judges, if there was a situation where that particular judge clearly went beyond their validity and no one would pay any attention to what they said, they went off the deep end, they're crazy, we don't think of it as an instance, but if they were within their official boundaries to say what they were saying, then the law is now what the judge said, if that's what the officials are grouping together and saying. So it follows what the kind of the mass of officials, and if they're all over the place and the officials don't know what to do, like seemed to be happening in Poland for a while, then you have a series of problems and the system can be kind of disintegrating. It can reconstitute itself if they fix the problems, as they seem to have done in Poland, or at least they seem to be on the way to. But yeah, you can have moments in which the institution loses its structural integrity, as it were. right? So that could be something that's going on if judges start deciding against the text. But if everybody goes along with what they're saying, then that's the new law, and the thing that they abrogated when they said against it doesn't seem to be counting anymore. So I would follow Kelson in that regard. International law is customary law, and then you talked about use Kogan's. I mean, there's two different things there a little bit. I do have I have a paper on how customary. I mean, Steiny, I guess, probably would know the most about it because he was the editor of the co-editor of the volume in which it's published. But there's which I try to explain a little bit more how customary law can still be the basis of institutions. It still requires the official recognition of that, and so in international law it's a little more complicated to try to pick out who the officials are. But once you have a kind of officials, whoever they are, there may be a web of them in the international community of certain officials who are recognizing each other's treaties and stuff like that, then that can still, it's their recognition that elevates the customary norms to a legal status. So even if the original norms were customs, they can elevate themselves to law by official recognition in some way. Use Kogan's, and you're talking about things like torture and all these other horrible things, and they have an obligation, even if they allow torture, that they're violating international law because they're going against it. I mean, obviously we don't want them doing that, right? That's terrible. But the point that I'm trying to make is that it would all depend on what the community of international legal officials deem to be torture, and whatever they deem to be torture would then be what's illegal for one state to participate in, right? So it's not that they are actually able to make it illegal to torture, because that would require a fact that's not a social fact about whether something constitutes torture. It's a let's say from critical morality. So what I'm saying is you can't actually make it the case that it's illegal to torture if that's an element of critical morality. What you're doing instead is you're making it the case that it's illegal to do what most of the relevant officials say is torture, right? Does that make sense?
Yeah.
And then finally, if they, what about passing an act that it makes it illegal to be a certain way, like to be an LGBTQ plus person or something like that? I mean, I think it's valid. It's terrible, but it's valid, and it's precisely because it's valid that it has whatever status it is. I mean, you're saying that these people will have a different institutional status within the legal system as a result of that. And they say the same thing here, right? I mean, in the United Kingdom, one of the things that you teach the first year public law students is there was a result of this principle of parliamentary supremacy that he said before, that if Parliament passed a law that said all the blue-eyed babies have to be chucked in the Thames River, then all the blue-eyed babies legally have to be chucked in the Thames River. That doesn't mean everyone's going to go do that. Hopefully no one would do it. But that's what the law is, right? And so, I mean, when you start doing those terrible things, hopefully people stop obeying the law. But that's still what the law is saying, that's all.
Okay.
So there's one question what the law says, another thing whether you should actually do anything it says, and that's up for grabs, so to speak.
Okay, I understand why just a final point. I understand why I disagree. Then, for me, for example, when those people are not obeying the law and not killing the babies, they would be obeying the law because there are principles that are superior and anterior to all that, which is be like human rights.
Right. So I would say, why are we calling that law? Why don't we just say they're doing the right thing? They're obeying morality, which is more important than the law. And forget about the law, do what's morally right. I would say that, always.
Perfect, thank you.
No, thank you, Natalie. Thank you, Ken. I think